Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode number 70 of Business SOS. Thank you for listening, and I hope that the information we're providing to you is valuable to you as you navigate the challenges, legal challenges that you face in your small business. So let's get right into it. And I'm doing, in the last few weeks, I've been doing 10 common mistakes, and I'm going to continue this theme and different topics, and then we'll have some guests coming in the next few months as well, so we can have some variety in the show. So today I'm going to talk about discovery in the context of litigation, and the topic today is 10 common mistakes business owners make when responding to discovery responses. So first, I want to talk about what is discovery in litigation. When you're in a litigation, when you're in a lawsuit, there's going to be, people file the lawsuit, the people answer it. There's going to be something called discovery, which discovery takes a significant part of the litigation process. And also discovery and motion practice. Those are two areas that take a tremendous amount of time and resources in preparation for trial. So discovery is broken in two different parts, and I'm going to try to be as simple as possible, not to go into really a legal rabbit hole here into the rules of discovery, but it is basically in two different areas. You have written discovery and you have testimonial discovery. So what is written discovery? Written discovery is broken in three different parts. The request for production, a request for interrogatories, and request for admissions. So let's talk about those first. Request for production of documents is exactly what it means. You basically have, they will ask you a number of documents for you to respond to, and vice versa. You're going to respond requesting that from the opposite side. And I'll just give you a number of examples. So say you're in a contract dispute, say a real estate contract dispute, that say the owner decided not to back out of the deal, and you want to sue for real estate commissions. And I'm using that as a very simple example. So say the broker sues the homeowner or the property owner for the unpaid commissions, and the property owner basically saying, no, I canceled the contract, you did not receive it on time, you did not provide this buyer, etc. So an example of the type of discovery that would be requested from the broker, as an example, would be any and all documents between you, the homeowner, the property owner, and the sales agent from the time of the signing of the contract to the present time. Documents also are defined in the definitions and instructions of most requests. Documents is a very broad term. It's a term of art. So that includes email communication, that includes text communication, that might include voice messages, anything that you can elicit information from, that would be in the quote unquote documents umbrella. So it is not uncommon you have a list of 30 or 40 different requests, a production of documents coming to you as a party to a lawsuit, and vice versa. The attorney will prepare a list of documents to be requested, and they're very broad. And in essence, the rule for discovery has to be relevant to the cause of action and likely to lead to a discovery of admissible evidence. So in Florida, the discovery rules are very broad. Yes, the judges keep you kind of in check and keep you narrow to make sure you don't go outside of the scope of the lawsuit in what we call a fishing expedition. But for the most part, the discovery rules are very liberal in Florida, that you basically, if it's something relevant, the judge will allow you to request that document, and unless it's confidential, we'll go over that later on today. So that's a request for production. If you receive that request for production, then you and your attorney will discuss, what documents you have, what documents you do not have, what documents exist or do not exist. And the way I do it in my practice is that when we receive discovery request, and for all these, you have 30 days to respond. But doesn't mean that you have to wait for the 29th day to provide that information to your attorney. You have to begin to work on that information as soon as possible, simply because there's a drafting process along the way. And I'll go over that as well. So that's request for production of documents. Request for interrogatories is you're going to be answering questions under oath, and the actual answers will be notarized, will be verified, and they're questions that you will answer under oath. And I'll give you an example of a question going back to the breach of contract dispute. Say, for example, the property owner says, the contract was not breached. The agent did not do his job. He did not provide a buyer for the property. So, a question could be, provide any facts which support your position or your contention that the agent did not do his or her job to provide a qualified buyer for the property. And I'm using that as a very broad general example. A question for the broker could be, something to the effect like, is it your position that you provided a buyer for the property? Please provide any and all documents which support that position. That's the production request. An interrogatory, please provide all facts which support your position that indeed the buyer that you presented to the homeowner or the property owner was a qualified buyer. And I'm just giving you that as an example. It's a very broad, but just the type of questions that they may ask you in a interrogatory. It's basically asking you for facts which support or facts in which you deny. It is basically providing facts. It is important to look at those carefully and draft them properly, and the attorney can help you with that. Request for admissions, that's exactly what it means. It's self-explanatory. Here, the one party said the plaintiff will send you a list of, they have up to 30 admissions, and you can ask for more with permission for the court. And you can ask, and the objective of those admissions is to get them on the record for the purposes of summary judgment, for the purposes of trying to get you to admit, and that way you don't have that matter will be undisputed later on. And most of these get denied. And the reality is, if you're being sued, you get a request for admissions. This is something very obvious and very clear on the record. Most of them most likely will get denied. I just gave you a very simple example, going back to our example of a real estate deal that just didn't go well, that one broker is alleging that the property owner breached the contract. One broker may send an admissions, admit that the real estate broker, ABC, provided a qualified buyer for your property. Admit or deny. Admit or deny that you decided not to, pursue the contract, closing the contract, even though the offer was within your required purchase price. And I'm just giving you that as an example. In reverse to that, from the property owner's perspective, he might basically ask a question to the effect, admit or deny that the person that was brought to the offer that was presented to the property owner was not a qualified offer. It was not the offer within the purchase price. Admit that the real estate agent did not fulfill the terms of the contract. I'm just giving you that, of course, as an example. Every situation is different, but I just want to give you a flavor of the types of questions that you may have under request for productions, interrogatories, and admissions. Now I want to go into testimonial discovery. That's the position of parties and the position of witnesses. The parties, exactly is what it means. They're the people, the parties to the lawsuit, the plaintiff and the defendant. If there are multiple parties, then everybody who's listed in the lawsuit will be deposed or should be deposed. And then you have the position of witnesses. Those could be fact witnesses that may have some knowledge of the lawsuit, where they may have some documents. And then you also have expert witnesses that sometimes are brought into a lawsuit to provide some expert testimony as to a particular topic. And there's a third category of testimonial discovery, which is depositions duces tecum. In this particular case, we request documents from a third party who may have documents but related to the lawsuit, but we do not necessarily need to have their testimony. And I'll just give you an example. And it's common in partnership disputes dealing with they might have financial records. So it is common to issue a subpoena to the bank to get the bank statements of a particular company, and those are usually supported with an affidavit saying these are business records that were prepared in the normal course of business, and that's the way that we can admit these documents into evidence. So now that I went over the kind of an overview of discovery, what it means, now we're going to go into 10 common mistakes. One of them is failure to respond on time. And these, in my opinion, are unforced errors, simply because they can be avoided with proper planning. And, you have 30 days from the time your attorney, or you, if you're doing this on your own, which I do not recommend, you have 30 days from the date of service to respond to the discovery. So procrastinating and not acting upon it quickly can lead to delays. Sending the information to your attorney at the last minute will inevitably delay the process. And I'll go over that in one of the mistakes later on. So it's important to plan accordingly. And what I do in my office, when we receive those, we try to get everything done within 20 days. And we have a process that, our paralegal case manager, Richard Ferriello, goes over all the discovery requests with the client, and then they do a rough draft. If there might be questions that the client may not understand, and we go over those to make sure they understand them. And then I'll see the rough draft, and then I begin to refine the process further and further until then we can submit a final product to opposing counsel. But it's a process that goes along the way, and it takes several rounds of drafts to get to the final product. It's not automatically happens. Mistake number 2, providing incomplete or evasive answers. This is important because especially this can create what is called discovery motions, discovery disputes which judges do not like. So if you have interrogatories that they're evasive, they're not clear, you're going to have motions to compel better answers. Same thing with the documents that you have what is called custody, possession, and control. That you have if you don't have them available, you have the ability to get them, then you have an obligation to get them and request them. So that in itself, is something that should be avoided. And an example in terms of a question that is commonly asked, that I commonly ask in interrogatories, is explain fully and with specificity the facts that blank. So it's important to understand the question and answer it fully and provide complete or evasive answers. Now, if you do not know the answer to the question, just tell your attorney, I do not know the answer to this question. I do not know what it means. Sometimes there are documents that are requested that you don't have. And that's fine because remember, the attorney is brainstorming what documents you may have in order to try to get them from you. So it's possibility that a request, you might not have the document, or it might be a duplicate request that already has been answered in a prior request. That happens very often. This leads me to mistake number 3, failure to understand the question. And there are 2 different categories here that I break down. One of them is the language issues. Sometimes we have clients that primary language is Spanish, sometimes it's Portuguese. And so a discovery request will be in English. So there might be a issue of the translation, interpretation, and in those cases, we try to facilitate through a translation or through interpretation of the question, what it means, so that way it can be answered correctly. The second part is misunderstanding the question. So in that, because we look at, they answer the question that they believe was answered, but they don't understand the question that it was asked. So those are mistakes that can be avoided by simply asking your attorney, what does this mean? Sometimes in interrogatories or even in production requests, they ask information that are really legal questions that should be brought, that only the attorney can answer. We raise the objection and we'll handle it that way. Mistake number 4, failure to disclose everything to your attorney. And I went over that several podcasts. I've actually mentioned that. It is a very common mistake. And I know sometimes that, clients want to withhold information, they may be embarrassed, or they just don't want to say it. But the reality is sometimes it's better to tell the attorney, and I call it the good, the bad, and the ugly. Tell everything to your attorney, even if it's something that is not in your favor. Tell your attorney, because it will come out at some point, and usually at the worst possible time. It might become in a direct examination, it might come in your deposition when they're deposing you under oath as a client, and then there might be a question that, in the preparation that was not discussed or you did not disclose, or some issue, and then in your deposition it came out an email or a text message that nobody knew about it. And you're basically putting your attorney at a huge disadvantage for him to or her not to have that document beforehand or have that answer beforehand, because if the attorney knew that, the attorney would have been able to develop a strategy on how to handle that. So it's important to tell the attorney everything about the case and not withhold information. And a common answer that I get is like, I just didn't think that was important. I get that very often. I'm smiling because it's just I get it very often. And I say, I wish I knew that sooner, but we'll deal with it, okay? And sometimes the information that is withheld is really not, is peripheral, it's not that essential to the case, but sometimes the information that is withheld is extremely important, and it can change the direction of the case. And it's better for you and for the attorney to have that information right up front, so that way it can be handled appropriately. So that's a mistake that I see often, or the client say, I don't want to disclose this information, and there are rules that there's some protections in some cases that you don't have to disclose. And one of them, I'll tell you, is trade secrets. And that, that's something that will have to go to court, get a protective order that, to prevent you from disclosing some information with a formula, whether it's a list of clients. So there are ways to protect information that is confidential and privileged by letting your attorney know, I don't want to say this. Now, if it's something that is not privileged or protected, there might be ways of handling it in such a way that you can still comply with the requirements of the law. Another one here, which I think is number 5, if you're not producing documents or producing irrelevant documents. I mentioned before, documents are text messages, emails, voice messages, graphics, pictures. All that is considered a document, usually in the document definition that is usually very broad, and most discovery requests come with a page called definitions and instructions. So that that definition is important. It's important to our attorney to review the definitions and tell you what documents mean. The way I look at it, produce all the documents, don't withhold, simply because the other side may have some of those documents as well, and we're going to do the same thing to them as well. This side is going to have to provide documents. Number 6, failing to preserve evidence, and it's called spoliation. This is very important. Now with electronic communication, pretty much every text message can be retrieved. There's information that is stored in servers. It's not a good idea to try to delete documents that will be harmful to your case. Okay, you have an obligation to preserve all documents that are relevant to the case, so is the other side. If there's a situation where the court finds that there were some documents that were deleted to try to avoid being presented at litigation, the court can issue sanctions against that party who is found that intentionally deleted evidence for the case. The sanctions can be severe. It can be by removing some claims, could be by issuing monetary sanctions, could be striking the pleadings. There's a range of sanctions that the court can impose for spoliating evidence. So my advice is don't do it. If there's something that is not favorable to your case, discuss that with your attorney, and the attorney will decide how to handle that particular piece of information. Mistake number 7, admitting to facts without careful review. And that goes into interrogatories and also in requests for admissions. The requests for admissions are not for your benefit. They're for the benefit of the plaintiff or the defendant, and they're designed to gather evidence to really use against you in your case. So it's important to review those admissions with your attorney to determine whether or not, A, that could be objected to, yes, the way the question was phrased, what was the admission, how you can actually admit part of it or deny part of it, the different tools that we have available and how to respond to that. But also this goes into, I'm going to write here depositions, because very common in a deposition, what happens is the following, is that, people get tired, people get relaxed in the deposition, and they get comfortable. At the first few hours of the depo, everybody's kind of on edge and listening to every single question, every single word that is asked. And once you get past the second hour, people get a little bit more comfortable, or they get anxious, but it's very common for people who are in a deposition to volunteer information and not answer the question that is asked. So this is what is called mistake number 7, admitting to facts without careful review. And I would say careful review or consideration of thought, because an attorney asked a question, and sometimes the person who answering the question gives the answer that he believes the attorney wants to hear, as opposed to answering the question. And in that particular scenario, the attorney cannot do anything. The information is already out. Or they answer the question and they expand on that question and they answer with information that was not asked in the first place. So it is important to listen to the question that is asked, answer truthfully, and answer the question that is asked. It is not the job of the deponent to fix or to correct or to add more information to an answer that has not been requested. And I see that very often. And no matter how, it is expressed is that, just listen to the question carefully. And again, if you do not understand the question, you need to be rephrased. The attorney who's asking the question can rephrase the question to make sure that you can understand it. But I see that very often. People just volunteer or they expand and then go into long narratives out of a simple question. And what it does, it just creates more answers, more questions to ask. And I just give you an example of that happens very often, especially that we have cell phones here. And I just basically going back to this example that I started earlier, on October 5th, did you receive on October 5th, the salesperson, presented to you an offer for, say, $400,000 to purchase your house. And I'm just making that example up, okay? And an answer that the homeowner could say something, and I'm just using this as an example, of course. It said, I'm not sure if it was October 15th, but I remember getting an offer. I'm not sure about the amount, but I have the text message here on my cell phone because we text a lot. So maybe I can take a look at that and answer the question. The moment that the deponent or the person answering the question refers to another place where information is available, the attorney is going to make a note to that, and it's going to begin to ask questions about that particular subject. So you had text messages with the salesperson? Yes. How many of those do you have? Yes. Do you provide all of those during discovery? Most of them. So then ask which ones you do not provide. So you see what I'm saying to you is that, that by basically providing another source where information can be gathered, the attorney is going to go in that direction and begin to ask questions about that particular subject, which was not planned. It happens in every single depot that a new topic is brought up that was not anticipated, and the attorney, rightly so, has the right and the obligation to begin to inquiry about those new topics that he did not anticipate, but were brought up by the answer to the question. Okay, so that's just one example that I just want to share with you. The mistake number 8, failing to keep detailed records organized and labeled. It is important when you provide information, especially in discovery, they have to be labeled, and we use Bates numbering simply because it is just an easier way to keep them organized. And when you produce them to opposing counsel, then we can both refer to Bates number 100, Bates number 300, and it's just a better way to keep things organized as well. So what I usually see is that we get, a ton of documents, and they are just completely random and disorganized. They're not in any shape or form. There are email threads that are out of any order. And what happens when we receive information that way, then we need to organize the information, and that just takes time and money. So the more organized you provide information to your attorney in response to the discovery, the better. So, and I'll give you an example. Say you get 30 different production requests, and you just basically send your attorney 100 documents. And you don't say, okay, which particular documents is request number 1, number 2, number 3. So the attorney and the staff will have to go through each individual document and find out to which request that document belongs to for every single document. So the better approach is these documents that I'm providing to you, this set of emails, will answer request number 1, 3, and 5. Just using an example, because it might be repetitive, and that's fine. But we need your help as attorneys to tell us which documents respond to what request, because you know the facts better than we do. You lived it. We don't. So providing that information in an organized fashion that will save time and save money, especially to you as a client. Mistake number 9, overlooking privilege and confidentiality issues. That goes into financial documents, communication with your spouse, attorney, CPA, doctor, therapist, spiritual advisor. And I'm not going to go into a great deal of detail as to what information is privileged or not, but I'll just give you an example. A question that is commonly asked, who have you spoken to about this particular case? Anybody that you have spoken to, anybody that you have shared information about the case, a common answer will be the spouse. Well, the spousal privilege. So that information cannot be gathered. That answer, whatever you spoke with your spouse, it's privileged and confidential. That cannot be discussed. Information with your CPA, with your attorney, that's privilege. And there are other categories of privilege, But I just want to share that with you as well, that it's important that not to provide information that is privileged to the other side, and the attorney will know which information is privileged, which one is not. Number 10, this actually is two-part, not updating, supplementing the responses to discovery, and not objecting to discovery. The objection to discovery, just briefly, could be an objection because it's irrelevant, burdensome, could be information that is privileged. So there are a number of objections that we can raise, but the attorney will know which objections to raise. So that's not up to you. If you have an attorney, if you're doing this by yourself, you're not going to know which objections to raise. The attorney will know that. Not updating, supplementing responses. We have a duty to update information. Say, for example, you have a production request, and then you send the emails and the documents that you had at the time, and you submitted them in good faith. But later on, you find out a piece of document or a picture or a text message that was not included in that request initially because you did not find it. Maybe perhaps it got lost in the shuffle, fell through the cracks, and you say, you know what, this should have been produced. Then we have a duty to produce that document to opposing counsel. So listen, it was inadvertently, it was not produced here, or we found it. Here it is. So it's important to supplement the discovery. Last but not least, and this is a theme that I frequently discuss in the show, is not hiring an attorney to handle litigation. If you are in a litigation in a lawsuit, handling yourself, you have discovery request that is sent to you by an attorney, you're not going to know what to do. You're not going to know how to respond to that. It is important that if you're in a situation that you're in the middle of litigation and the other side has an attorney, you have to get an attorney. It surprises me the number of people that choose not to do so because of cost. And my answer to them is it'll cost you more not hiring one. You do not know the rules of court. You do not know how to navigate that field. The attorney will know that. So trying to go on the web and trying to do it yourself, it's just a formula for disaster. And the unfortunate part of it is that when you're handling a lawsuit by yourself, you are held to the same standard as an attorney. You're held to that standard in reference to knowledge of the rules of court, civil procedures, and unless you're trained, you're not going to know this. So the best thing is to hire an attorney to handle this for you, and that's just a bonus mistake number 11. And just go back to recap what we talked about today. We went over the discovery process, written discovery, testimonial discovery. The 10 common mistakes: failure to respond on time. It's important to begin working on that when you receive the request. Providing incomplete or evasive answers to discovery. Failure to understand the question. Failure to disclose everything to your attorney. Not providing documents, producing irrelevant documents. Failing to preserve evidence. It's important not to delete. Admitting to facts without careful review. Number 8, failing to keep detailed records organized and labeled. Number 9, overlooking privilege and confidentiality issues. Number 10, not updating supplemental responses. Number 11, it's a bonus one, not hiring an attorney to handle the litigation if you're in the middle of a lawsuit. So I'll leave you with that today. If you want to reach me, you have any legal questions, my email is rich, R-I-C-H, richsierra.com. My website is floridasmallbusinesslegalcenter.com if you're interested in learning more about our legal services. We're on Facebook at FSB Legal. If you want to watch the video of this podcast, we're at youtube.com/@RichardSierra. We're on Instagram at FSB Legal. If you want to give us a call, our number is 866-842-5202. Remember that Business SOS, 8 Common Legal Mistakes Business Owner Makes and How to Avoid Them. It's my book. I'm very proud of it. It's available on Amazon, Barnes & Noble. You could ask for your local bookstore as well. If you like the podcast, please follow us, give us a review, hopefully a 5-star review, share it with your friends if you find this information useful. And we're available on Apple Podcasts, Spotify, and wherever you enjoy your shows. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. Remember that my goal is to help you succeed.